Hello, everybody. Hello, hello. I'm just writing a sticky note here. How are you doing? Hello, hi there. Hello, hello. Little Friday bonus live for everybody tonight. Hello, hi. Good to see everybody. Here we are. Let me make sure I'm set up here. Hello. You watched this live. Oh, good. I had not had a chance today. Good evening. Hello, everybody. Hello, yes, it's a little bonus tonight. Little bonus, everybody. I had wanted to watch the RICO hearing. I had not had a chance to see it yet today. So I thought I would hang out and watch with everybody else if that would be okay. Well, hello, thank you so much. Thank you. Hello. We certainly will not be watching all of it, but I thought maybe we could watch some of it together and talk about some of the issues going on. So I've been having a great Friday so far. It's been very relaxing, so haven't seen it yet. Okay, great. Hello from Colorado. Hello, everybody. Hello. It's good to see you. Has the video been vetted? Great question, Georgie. Yes, as many of you may have known, I had a little incident previously, but yes, we're sorted. Yes, hello everybody. Hello. Yes, I'm on a little bit later tonight, but this is what worked for my schedule. I thought it would work out okay for everybody because it is a Friday. So I'm just happy to come and hang out. We'll just be watching this hearing together, and I will be making some comments here and there and answering questions as we go through it. So, yes, actually, we will see. We will see what happens. But I think I've got it figured out so that we don't have any commercial breaks. What? I know. Oh my gosh. Yes, I'm very excited about that. So, hello, good to see you. Good to see everybody. Yes, so welcome in everyone. I've got the what I've got set up here, and this is a huge hearing, everyone. So I figured we would just go through a little bit of it and just kind of talk about it. But so here I've got this is the Georgia RICO case regarding Trump, and it's a hearing that was done earlier today. They did tape it, so I think tape, is that the right word? They did record it. So we are able to, no commercial breaks. I know, the evidence bag. I'll bring it back, Georgie. Oh my gosh. Yeah, I'll bring it back sometime. But for tonight, I thought it'd be kind of fun so we could kind of just dive on in. Everybody, it's been quite a week. So he was not there, but his attorneys were there. And this was the first time they were really arguing in front of Judge McAfee. I thought Judge McAfee did a really good job. I saw a lot of highlights, but I haven't seen the actual hearing itself. So I thought it would be great for us to kind of hang out and watch it together for anyone who is interested. So I will go ahead and hit play, everyone. Now I am here. My hand will pop in occasionally to say hello. So yes, we're taping it. So here we go, everybody. Let's get started.
Sure. I think that makes sense. And to the extent any of the motions
He's just started.
Beyond what a particular defendant is charged with, I don't think that would be covered by the adoption. But I think that's good to take that motion by motion. Thank you, Judge. On the issue of the prior order, I know that a lot of the things we may be talking about today were addressed with the prior co-defendants. However, I think defense counsel have raised new aspects. There's case law to go through, and we did have to issue that order under a compressed timeline. So just for purposes of the hearing today,
talking about the speedy motions for demurs.
More persuasive authority than it would be binding.
Thank you, Gravity.
And we'll just go through it that way.
He starts out so cheerful, everyone.
The last thing I know we said we'll save housekeeping to the end, but before I forget about this, I know in a lot of the notices and the orders, I've been using the doc clarification. I'm not sure that that's still on the public-facing website that you can even see what I'm referring to when I say doc so-and-so. And I've been told from the clerk's office they're planning to have that updated by March or so.
By March. Oh, dear.
We can just take a wild guess at what I'm referring to and go from there. But I think that's as close as we can get to Pacer right now. And I think based on the volume of motions.
Okay, let me pause here. Yes, I can turn the volume up. You bet, everybody. And I had another question. Did his lawyers file a dismissal or postpone motion? I thought I saw something that they did. So what they're doing right now is they're having a hearing on motions for a demur, which is they're trying to get the case dismissed. So that's what this hearing is about. I'm not sure what they have filed after this, but that is what was done here. So let me turn the volume up a little bit, and here we go.
I'm going to have to keep doing that. All right, anything else? Let me throw it open to the floor before we dive in. Anything from the state, Mr. Wade?
Nothing from the state.
Okay.
You got it, Hitch. No
Now,
problem.
anything from any of the defendants here today, or counsel, defense counsel?
No, Your Honor.
Okay, so the first thing we had, according to the proposed agenda, was dealing with the ECA and the supremacy clause. Mr. Gillen, you're taking that one?
Well, Your Honor, what we're going to do on behalf of Mr. Shaver and others have adopted our motion. There are two components to our motion, the ECA and the supremacy clause. So I'm going to be addressing some of the comments about the ECA, and then Ms. Pearson will be handling the supremacy clause issue, if that's permissible with the court. And she'll, I believe, also be addressing
This is recorded from earlier.
Raised by some of the others dealing with the supremacy clause issues. Beginning. Thank you, Your Honor. Now that we know that the prior rulings are only a persuasive authority, I will acknowledge, of course, that we have read the court's rulings in Chesbrough and Powell and understand the court's position on some of those issues. During the course of our presentation today, what we're going to be doing is giving the court our view of the ECA and our view of the supremacy clause and the interaction between the federal ECA and the United States Constitution, the supremacy clause. Some of the things that to highlight some of the things that we'll be bringing to the court's attention that may address some of the persuasive authority that the court has previously ruled, but that we would ask the court to consider our views on, would deal with whether or not, frankly, the
All right, let me pause it here. This is Judge McAfee's YouTube channel. Actually, I'm not sure if this one is. He does have his own, and he does all the streams there. But there is also a news site that streams them as well out of Atlanta, Georgia. There, so if this is on YouTube, and there's several different. This is 11 Alive is the name of the news station. There's several different places you can go. I liked this one because I thought it had a better camera angle to it. So. Cheated and watched a bit of it earlier. Oh, excellent, excellent. Love it. Yes, I will be doing kind of a Q&A as we go through this, everybody. Who currently is talking? We've got one of defense counsel. I believe this is one of Trump's counsel. He has two that are going to be arguing, but then I may be mistaken. This may be a different guy. So I'm going to have to double check on his name. I don't have the attorney's names memorized, but I do know it's one of the defense counsels, and there are multiple defendants being represented here.
Preemption issues apply, we believe, and this will be addressed by Ms. Pearson, whether or not we think preemption does stand here and has been established, and particularly in the area of conflict of preemption, where one of the standards is where state law, quote, stands as an obstacle to the accomplishment and execution of the full purposes and objects of Congress. And that's something that Ms. Pearson is going to be discussing and attempting to have the court understand our view of that, which is
right, the
somewhat
supremacy
different
clause.
from the court's
Let me grab my
ruling that it made
Constitution.
in the Chesbrough-Powell supremacy order issued earlier in this case. The other issue that may come up, or will come up, during the context of our supremacy argument will be in the court's previous orders, the court references whether or not the ECA compels.
Okay, everybody, let me pause it just for a minute. The supremacy clause. I went up to grab my Constitution, but I was actually sitting on it. So don't tell my teacher. All right, so here's the Constitution, everybody, right? I'm sure everybody has it next to them. They're sitting. Oh my gosh. All right, remember the 7 articles design the government. Now, it's under Article 6 is the supremacy clause. So let's take a look here. And it says, let's see. Okay, this Constitution and the laws of the United States, which shall be made in, oops, I'm off. There we go. We're up a little higher. In pursuance thereof, and all treaties made of which shall be made under the authority of the United States shall be made under the authority of the United States shall be the supreme law of the land. That's the supremacy clause. So it's stating this Constitution, again, I'm not quite in frame. This Constitution is the supreme law of the land. That's the supremacy clause that they are talking about here. So when they're talking about what's more important, they're talking about, the federal Constitution and his role as president of the United States is more important than any kind of a state situation. So that's what they're arguing here. They're saying his role in the federal government is supreme to any kind of criminal conduct he did at the state level. That's the constitutional argument. So there you go.
Or a requirement. And the argument that will be made by defense counsel is, respectfully, we disagree with whether or not that is the correct criterion upon which the conflict preemption should be judged. Rather, it is the question of whether or not it impedes as an obstacle in accomplishment of execution of the full purposes of the objectives, and that it impedes the right, not an obligation or duty, but the right. So she will be talking about that. The other area that we did file a motion yesterday asking the court to take judicial notice of the filings in this building, in this court.
Thank you for the gifts, everyone.
As it relates to the lawsuit that was filed on December the 4th by Donald Trump and David Schaefer challenging the election. We've attached the docket sheet as an exhibit. We believe that there's no question about that. The purpose of that is, one, to show for the record that
this is Mr. Schaefer here.
There was no adjudication of it.
He's referring to a lawsuit they filed.
So that I think that we don't necessarily think that it is mandatory for the purposes of our argument that be included, but for the sake of completeness, we would like the court to take judicial notice of the filings in this clerk's office, which should be beyond dispute. And in that context,
you will slowly see the light fade from the judge's eye. Okay, that will slowly happen as time goes on. We're not going to be watching the whole thing, but as we go on, it gets to be a lot.
Documents or additional facts, but given the fact that the only thing that's really necessary to make an adjudication here, frankly, in light of the supremacy argument that will be made by Ms. Pearson, our view is that you don't have to have the presentation of any facts at all. But again, in the abundance of caution, we would say that if the court...
Yes, there'll be a lot more plea agreements.
Within your plain bar, we would say that the record really on that is basically complete by the filing of the lawsuit and the fact that it wasn't adjudicated, triggering the ECA safe harbor.
The judge is probably trying to count how many people or have been accused of murder sitting in his jail right now. It's probably what he's thinking about. Well, this guy goes on and on about the supremacy clause. He's like, we've got homicides to try, people.
I hope the court will be patient. I know that this isn't the court's first rodeo on ECA.
Land the plane. I love it. Oh my gosh.
We appreciate that.
Before we dive in, why don't we handle this issue of the motion that you filed? I don't know if today would...
You probably can't tell.
An evidentiary hearing, but...
You probably can't tell everybody, but he has this huge binder up on the bench. It's about this thick, and it's all of the stuff for the motions today. So it's, oh my goodness, we're in for a treat.
even if it's by way of proffer or judicial notice, let me just hear from the state. The two issues were recognizing the prior version before it was amended of the ECA and something that's on the Fulton County's docket. Were there any concerns about that being recognized for the purposes of the record, but not foreclosing any of the state's arguments it may make in response to it?
Judge, we just object strictly on the grounds that it's not relevant to what the court's going to take up today, because as you pointed out, this is not an evidentiary hearing. When we start talking about facts that are outside the indictment, when we start talking about bringing in evidence, we're moving into that realm of speaking demur, we're moving into that realm of something equivalent to motion for summary judgment. That doesn't exist in a criminal case, so we would object for those reasons. We don't think it's relevant at this point because facts outside
That's a
the
good
indictment
point.
is not something that the court should be taking into consideration as it relates to these motions to dismiss, the murders, and motions to quash.
That's an
So recognizing
excellent,
the relevance arguments and
excellent argument.
how applicable you think they are to the motion under the 201 judicial notice standards, though. Any concerns that what would be accepted as a fact should not be?
Judge, I think as it relates to that issue, they're in the record, they're part of the court's public record, and so I don't think we're contesting the factual, the fact that these documents are there and that they are what they purport to be. Not agreeing to some of the contents of them, but they are what they purport to be.
Sure. Okay. And I don't think that's generally necessary for prior versions of a statute, but
This is the prosecutor, this is
counsel
defense.
has asked for it, and I don't see any reason why.
And all these guys are
we shouldn't-
defense
we can't
and this
make that
lady.
clear. So just for purposes of the record, we'll say that the motion filed on November 30th on those two facts is granted without foreclosing any other the state's arguments.
Thanks, Your Honor. Now, first the overview.
Oh my gosh, the overview.
Of course, the presidential electors are created by the Constitution itself. Our view is the state must show a specific grant of authority from the Constitution or federal law to exercise any power over presidential electors.
All right, so as we go through this, I will probably pause multiple times. So what this man just said was that the states don't have any authority over electors whatsoever, which is incorrect, bold choice. But he's saying in his first argument, to summarize, he's saying, show me where the law says the states have any kind of authority over who the electors choose for president. As we all know, it's written in the Constitution and also under the Electoral Count Act that power's been designated to the state. It's not specifically set word for word, but it's one of those powers that has been set aside for the states that has been known for a very long time, but that's his first argument.
And really, here we're talking about only two such grants. The first one for the Constitution regarding appointment power to the state legislatures, and that will be addressed by Ms. Pearson. The other by Congress through federal statute, ECA, to decide presidential electoral disputes by the ECA's safe harbor date. So that's the context in which we are saying that what you're looking at here is that this is the only way that the state of Georgia has any ability to then have any kind of authority over presidential electors.
Okay, so, and again, I'll pause it. Okay, you have to remember here, he is setting this up for appeal, but the problem, or what continues to be happening here, is that the defense keeps arguing the facts. They keep arguing and saying, you didn't have, we really thought there was a problem, and that's why we set up this other set of electors, and we really thought that there was a problem, and the Constitution and blah, 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 blah. So they're arguing facts here, which is for a trial, rather than acknowledging they're in criminal court because of a conspiracy. And the conspiracy is what the criminal charges. So this isn't about trying whether or not the election had problems or didn't have problems. That's not what it's about. It's about whether or not there was a conspiracy or a criminal enterprise. And so this attorney is going to go on and on and on and on about how they thought that setting up these electors as a backup was how they should have done it. And so therefore it wasn't wrongful, not keeping in mind that the whole point of the conspiracy was to keep somebody in power. How they did it's not really relevant, but he will go on with that anyway. So I'm just clarifying, everybody. This is why we have problems, because if you are in criminal court and you're fighting out in criminal court all the time, or a criminal judge like Judge McAfee, you're in criminal court all the time. You can recognize when we have a legal argument and a factual argument, and we can recognize also what's appropriate for court and what's not appropriate for court. But they are just going on and on and on about these intellectual academic arguments that are just simply not relevant in a criminal case. So, are they relevant? Yes, but not at this point and not in a criminal case like this. I mean, this judge has got like homicide cases to try. Meanwhile, this dude's talking about the Electoral Count Act. So,
Constitution or the federal statute, the 2020 version of the.
so this whole hearing is basically on a motion to dismiss. Technically, we call it a motion on demur or motion to quash, but it's the equivalent of a motion to dismiss, or in civil court, it would be a motion for summary judgments.
Electors meet pursuant to the Constitution.
Yeah,
in
this
their
is what they
respective
chose
states, and
exactly.
vote by ballot for president, vice president, presidential electors, assign, certify a list of persons voted for, and transmit the list. And we all know the tortured history of the president of the Electoral Count Act and sort of the chaos that had occurred in the presidential elections prior to the 1887 Act. So we're focusing here on this. What does the Act say? It says that the electors must meet and vote on the first day of.
He gets
the first
paid by the
Monday
hour. Could be.
at the second Tuesday in December at the place directed by the legislator of the state. In our case, of course, that was on December the 14th in 2020. Now, second point, presidential electors shall vote, quote, in the manner directed by the Constitution. That's also
The judge has to let him ramble.
Section 8.
Pretty
And then
much.
again,
I'm going
the
to just,
electors shall make
rather than stop it, I'm just going to mute it. So, yeah, he's pretty much rambling. Now, the thing is, his arguments are fine to make. They're good legal arguments. Go for it if he wants to make it. But he's in the wrong place to be making these kinds of arguments. So the judge is going to let him go, build this record up, build up what he thinks he needs for an appeal. But it's not going to necessarily be like, the judge isn't going to say, oh, okay, well, you're absolutely right, and then that's it. So this is more of a building that record for the appeal. I think someone had commented that earlier. And also kind of as a practice round for this attorney as well. But this attorney is not arguing for a criminal case like we normally would be doing for any other defendant. He's arguing these academic procedural questions that are just not applicable in this particular set of facts, but they think it is. So there you go. Oh, sorry. Hold on, everybody. Sorry about that. There we go. Okay. Whoops, here we go. We're going to fast forward. Sorry, I got the commercials out, but I do have to be careful that I don't accidentally get something that is unseemly on the screen. All right, here we go. At least I think here we go. Okay, wait.
as it relates to what happened here and what didn't happen here in Georgia.
Oh, my goodness.
Spend a little bit of time kind of reading this and then talking about it. And this is what Section 5 said in 2020.
He's like, I'm done. It's been 30 minutes. I'm done.
Prior to the date fixed for the appointment of the electors for its final determination of any controversy or contest concerning the appointment of all or any of the electors of such state by judicial or other methods or procedures, and such determination shall be made at least 6 days before the time fixed for the meeting of the electors. Such determination made pursuant to such law.
Oh, this is the safe harbor clause that he's going into here.
Prior to said time of the meeting shall be conclusive.
Oh, the stenographer. Yes, I agree.
Shall be conclusive and shall govern in the counting of the electoral votes as provided in the Constitution. So what that means is the state of Georgia and all the other states had an incentive given to it by Congress. The incentive was, look, if you follow
Section
5,
it kind of is, yeah.
then you get to be the absolute conclusive decision maker about who is going to be the electors or what outstanding controversies if they don't exist.
Judge needs a Red Bull.
Only if by, in this case, the
Hey,
safe
see
harbor
this?
date was
Look at this guy
December the
back
8th.
here. He's
Only
falling
if
asleep.
the state of Georgia gets its act together, and whether there was a controversy about the electors,
The judge
and it
can
had
stop
not
him,
been-
yeah.
If the state of Georgia had it
But he won't.
adjudicated prior to December the 8th, then what
Yeah, I think it was
the state
charisma.
of Georgia through the certification of the governor, that is conclusive. So the critical thing here is that every state, this is an incentive given to the states by,
Oh
by
no,
Congress.
the bunny hands.
Hey,
The
get
bunny
your act
hands.
together. Congress doesn't tell the state of Georgia, hey, this is how you have to go about setting up the
Yes, this is one of
procedural
Trump's
mechanism
attorneys.
for your determination about having a final conclusive result of your judicial challenges.
It'd be quicker if he just read it.
Every state can take its actions or take no actions.
It's not
State of
this.
Georgia
It's not that
set up
common to
whatever
ramble in
procedure is
criminal
set
court
up.
like this.
One thing we do know here is that
I'm just going to mute him again. So this isn't common at all in criminal court. No way. Our judges are like, get them in, get them out. You know, we're done. We got stuff to do. So it's like an assembly line in criminal court. We're not going to, even in our motion hearings, the judges are like, what do you got next? What's next? What's next? Let's get going. So this is quite a bit of just ongoing legal argument. I've never seen anything like this before in an actual criminal case where they're fighting about this kind of an issue. It just doesn't really happen.
then the state of Georgia then loses its ability to make a conclusive determination about which electors are to be counted in Congress. Once they did that, doesn't matter candidly how many times the governor of Georgia certified the results of the election or the recount, whatever. What does matter, and what only matters, is that there was a pending lawsuit.
Is he baiting the judge? No,
In this courthouse,
I don't
in
think
this
so.
county, challenging that election and that by.
No, I don't think he's baiting the judge. I think he truly believes that this is an academic argument that he feels is necessary to make for whatever reason. I think the judge is just inconveniently located in front of him.
Electors' votes are going to be counted in Congress on January the 6th.
But the state still plays a role, does it not? I mean, isn't the governor's certification supposed to be the tiebreaker when Congress is making the determination?
I do have captions on.
And the tiebreaker only
They're
comes
not
when
available
this
here.
happens.
Sorry.
If there is, for example, the governor did certify, we all know that, and we all know that the state of Georgia didn't get its act together, didn't have a final
Whoa.
adjudication, loses its ability.
Ooh, get its
to
act
say
together. I
that
see
is
now
the
what you're saying.
certificate of our governor, and it is conclusive. It wasn't under federal law.
It may not be conclusive, but aren't there still things happening in the
This-
state that matter?
We've got the
Certainly, but the only thing that matters
projector screen
as
here.
it relates to this federal law, the only thing that matters is they didn't get their act done and get an adjudication in time. So what happens? What happens after that?
That's interesting.
We're jumping ahead a little ahead of my PowerPoint, but that's
Please
just
jump
fine.
ahead. I beg you.
I think we all know what's in the PowerPoints. But what happens is that once they don't get their act together
I'm wondering,
by
Tiffany,
January,
I'm wondering.
December the 8th, then all bets about the conclusive nature of the governor's certification go away. But what doesn't go away, the governor's still certified, and what has to happen then is electors have to vote on December the 14th. Now, if there is a...
Oh my gosh, a weak PowerPoint. Say it isn't so, Georgie. No. Oh no. Oh my goodness. Thank you, John.
By not getting their act together, by not having a final adjudication, the that Congress gave the state of Georgia and all the other states. If you get your act together by safe harbor date, then and only then do you get the final call on who the electors would be. But they did. Because of that, then
Dr.
all of
Pepper slushy.
the Democratic electors
Oh my
and
goodness.
the Republican electors are in effect all at that time
Is being back to death.
contingent electors because there is no certainty about
Oh my
who
gosh.
or which slate will be selected under federal law. As we know, what
He's
happens
addicted to us as we are to you.
is that
Absolutely,
once that
Kristen.
safe harbor date
Absolutely.
passes, then the issue,
Maybe more.
now we're getting over into section 15 of the ECA. But once you get over into there, then the 2020 version tells us what
I nodded
steps
off.
are taken to make a final determination.
Don't listen while driving,
about
everybody.
when electoral slates will be decided. You're right. A lot of things are happening in the state. A lot of and let's go over things that could have happened.
Is it the
that
fridge in the
didn't
center?
happen. For example,
Here,
there could
I
have
think
been,
that's a power box
adjudication
thing.
after safe harbor on the pending election.
Because all the
Of course,
stuff's
that would not
plugged
have been
into it on the
definitively
side.
conclusive as it relates to
Is there a
the
reason
safe
the
harbor
judge
date.
doesn't stop him?
The power is still shifted over to
Yeah,
Congress.
so sorry, I'm just muting here. Yeah, he's just making a record at this point. The judge just kind of asks him questions as he goes through it because they're just making arguments. Some people would say that this would be called a speaking demur, which is when you argue out your motion to dismiss. So he's just making this record and going into why he thinks the law is wrong or the way that it's been applied is wrong. So he's just making that it's a floppy drive, government courtroom, no funds for. Oh my gosh, John, a floppy drive. No, that can't be right. Oh my goodness. So yes, he'll go on for a bit, but then his partner, his cohort will come on. And then the state argues too. So it will go back and forth. They are given a time limit usually. So we've got a bit of a time limit and then the next person gets up to go.
What they can do is the following. They can sit there and they could go, well, now we know that the lawsuit was dismissed or was adjudicated against President Trump and David Schaefer. Okay? If that's the case, they can consider that. It's not conclusive. It's not definitive.
Okay, this is
They
Mr.
can
Schaefer.
consider that in making their determinations about what they're going to do. Or, for example, if on the other
Fiduciary?
hand, the lawsuit was adjudicated in favor of President Trump and David Schaefer, then Congress could then look at those facts as an adjudicator and make a determination about whether or not they should choose the Democratic slate that had been previously set up by the governor or by the Republican slate that had been sent in. So then and only then. But what happens in Congress is the following, and we all know.
I think it's the red flavor.
And this is an important consideration, Art. This is a process set up by Congress. The whole ECA is a process.
ECA is the Electoral
in order to
Count
make
Act.
sure that it can be done in an appropriate way that's approved by Congress, because they have the power to delegate. Approved by Congress, and the whole process involved.
They're arguing a motion to dismiss today. This is a recording from earlier.
The whole process involved everything that happened after December the 14th, upon which the adjudicator, Congress, could make a determination. So let's just say up it goes to Congress, and as we know, the procedure at the time of the 2020 was as follows. What was the procedure? Well, here we go. Were there objections filed?
It'd be more
by the
exciting if
federal
it was
and
acted
state
out with
regarding
Barbie
the
dolls.
election?
Oh my
the-
goodness.
If
Let's
there
see.
are
Let's see if I can
appropriate
find my
objections filed,
my
then the
dolls.
Senate goes and votes, and the House
Oh
goes and votes.
Here, I've got
Let's
one.
just say
Just
that,
do-do-do-do.
the House goes.
Oh my gosh.
Well, we think that it's the Democratic slate. Okay?
Oh
And
my
then the Senate
goodness.
says, we think it was the Democratic slate. They agreed. Once they agree, it's done.
It's,
They
yeah.
agree, and it's the Democratic slate.
Yeah, let
However,
me see if I can find.
the law in
There you
2020
go.
says that if the Senate and the House of Representatives disagree about which slate of electors would be received, then there is not an agreement between the houses of Congress, and then and only then does
Wait, I have-
Congress in its
I have
power
Fawny. Here's
go
Fawny.
back to the governor of Georgia and say, okay, tell us again, which one did you certify? And he says the Democratic slate, and that would be it. The point of all this is that at the time of the meeting on December the 14th, the meeting between the Democratic electors and the Republican electors were in furtherance of this scheme, the statutory scheme set up by Congress for a procedure to deal with these sorts of situations. And what happened is that we have a situation.
I'm not sure if federal act is a
electors on
scheme.
December the 14th did exactly what they had to do. Because if they didn't, if they said, well, I'm afraid that the district attorney of Fulton County might indict me if I meet and show up and follow.
I don't know.
My role in this congressional process and procedure laid out by the ECA.
Sometimes if you just give a lawyer a microphone, things happen. And not necessarily good things, but I think that that's what's happened here. He has some talking points and now he's just kind of going on and on about it. Yeah, it's a lot. Yeah, he's basically saying like, the law is wrong, so we're fine. It's the ego. True. It must be the ego. I'm not sure what else it could possibly be. What exactly is this time limit? Excellent question. I'm not sure. It seems like it's a lot. 2 legal pads and a microphone. True story.
We have the Hawaii precedent.
Oh my gosh.
Aware of all that. We don't need to spend a lot of
Look
time
at that.
dwelling
She's
into
like,
that.
please,
Perhaps
somebody
Mr. Pearson will
put me out of my
to some
misery. I
degree.
beg you.
With that in mind,
Oh my
by
gosh.
exercising and playing their role in this process, they did the only thing that they could have done in order to keep the process alive.
What?
Because if they did not do it, the state of Georgia, by failing to meet the safe harbor date,
Whatever.
if the threat is out there, all right, we failed to meet our safe harbor date of December the 8th.
The walrus hands.
Mr. Republican elector, if you show up,
True story. Take away the microphones.
Precedent, and if you follow with the ECA,
Oh my gosh.
The understanding of the ECA that you have to vote in order to determine whether or not
Trump requests
the
11,000.
Democratic or
It's a great question.
electors are selected by Congress.
Yeah, it's all computerized now. I think she's a clerk, actually. I think the stenographer's over there.
Through the district attorney's office to say,
He's paid by the word.
indicting you in a grand
Feels
jury,
like it.
if you show up, they're
What's the
defeating
safe harbor
purpose
day?
of the congressional
Yes.
procedure and
So,
set up in 2020, as we
again, I'm just muting. I'm not pausing because he is going on and on. But yeah, so the safe harbor day is basically what their whole argument is saying. Under the Electoral Count Act and under the law, we thought that because there were some questions about the election that we had to get this extra slate of electors put into place, or else, according to the ECA, then Trump wouldn't get the votes he would be supposed to have. So that's what he's saying there. So because the date was coming up and the court cases hadn't all been resolved at that point. So yeah, it looks like she's asleep, but I think I don't know. She may be writing a note to family saying, this has been great, but I gotta go. Oh my gosh.
It's clear from section
Why do you just say
15,
that exactly?
in
I know.
we can go to
Oh my gosh.
no, let's leave it right there, Anthony, just for a second. The next slide.
They might believe it.
the reason why we have this, it really
She's in the
states the
shop.
obvious. This is part of the suitor dissenting in
She's on Amazon right now.
and this whole issue about Section 5 is not
Save
serious
me.
and tells us what seems to be self-evident, at least to us.
Oh, my
That provision
goodness.
sets certain conditions for treating a state's certification of presidential electors.
Yeah, you write us still.
In the event that a dispute of recognizing those electors must be resolved in Congress under
This is
Title
a
3,
tape.
Section 15.
This is a 8-track tape
Inclusiveness
from
requires
earlier
selection
today.
under a legal scheme in place before the
Oh my
election,
gosh.
with results determined at least 6 days before the date set for casting electoral votes. But,
They're just making
says,
this up.
Justice Souter, but no state is required
Yep.
to conform to Section 5. If it cannot do that,
Laser
for whatever reason,
disc.
the sanction for failing to satisfy the conditions of Section 5
Oh my gosh.
is simply loss of what is called its safe harbor. End quote.
Even the
And that
camera operator.
and even
Like,
that
now this is the court
determination is to be
reporter.
made, if made anywhere in Congress. And so they're
She-
telling us the obvious.
She's
The state
admitted
didn't
defeat
get it done on
already.
time. They lose their ability to conclusively
Oh my
state
gosh.
these are electors, and as a result of that,
This
the
poor woman.
mechanisms under Section 15,
She needs a fruit
would be
basket.
in place. Next slide.
Oh,
Again,
how much is
on,
this attorney earning
Section
for this?
15, there are many
Whatever it is, it's
references,
too much.
providing for
Someone needs
more
to
than
dock
one
his
or two
pay.
or more returns from the state. If you go to the next slide, there are essentially 5 different portions within Section 15 dealing
Oh,
with
he's got
references to more than one
Oh my goodness.
of these certificates.
He really does. He
or
really
votes.
does.
All certificates
Maybe a
of
chocolate
paper purported
basket.
to be certificates is one. When all objections
This
be
is like
made,
the exact
shall
same
make
argument that they
any
did
vote
at
or
federal
paper from
court
the state.
and with Cheese Bro.
The two houses concurrently may reject the vote or
Absolutely
votes when
underappreciated.
they agree that such vote or votes
Defenses,
have not been
it's the
regularly
first
made by
piece
electors.
of a
If more than
multi-piece
one
defense.
return or paper purporting to be returned
Hello, Linda.
from the state has been received, again and again a reference in such case of more than one return purporting to be returned from the state. What does all that tell us? It tells us precisely what we're saying.
The name Cheese Bro.
This statutory scheme, which is set up.
That's an interesting comment actually about his wife. One thing that my significant other, my mate, would always do whenever I got home super late, he would come out and open the car door, pull me out of the car, and grab my briefcase and drag me back inside because he knows it's crazy when I'm in trial. Those times were such hard times. So I didn't even speak to him. He would just come out and be like, all right, here we go. into the house, and take another step. Another one. Yeah, he was. Yeah, I was just not even human at the end of the day during a trial. Even if I made it home, I just wasn't human. She needs a.
I think that should be our focus.
Well, I think you're, of course, being kind of saying you don't want him to get through my PowerPoint. My
The
timeline.
judge is trying to
That's
keep
fine.
him in
I'll
line
address what
here.
the court said. We're saying that our this timeline and our arguments concerning the scheme doesn't confine as the court in some of the orders that it made in Chesbrough and Powell as regarding the motion, the denial of the motion to dismiss for
Yeah, what's your focus?
some of the arguments on demur that it would be something that would be more appropriate for a directed verdict. With all respect, the persuasive authority we would disagree with in that context because what we have here is the record before the
Oh my
court
gosh, we don't
shows
have a directed verdict in
Now,
criminal cases.
everything that we have said is a part of this case. The court has taken judicial notice of the filings. And
Yeah,
the
directed
triggering
verdict.
mechanism
Let me
of
just
the
Let me just mute him. Again, I'm not going to pause it because he's still going on and on. So a directed verdict is what you ask for in a civil case. For example, at the very end of the state's presentation of evidence in Trump's civil case, the defense moved for a directed verdict so they would argue out why they felt that the state hadn't met their burden of preponderance of the evidence in the state civil case. So it should be tossed. So we don't do that in criminal court. We have motions to dismiss. We have evidence that needs to be kicked out. We have those kinds of things. But he's arguing this like it's a civil case, and it's not. It's a criminal case. Four people voted yes. I know. Oh my goodness. This poor judge. Why the judge and stenographer looking like how God take me away? Well, yeah, they probably are. They probably are like, put me out of my misery. What can I do to mentally check out? Please, somebody help me. Oh, we have a history. Yes, exactly. You know, this is what we train for, everybody. We train to stand up there, go on and on and on and on, barely make any sense, and have that all figured out later, sorted out later in the record. Oh my gosh.
Exactly what we've told the court. What they've done is lawful. And what they have done, frankly, in my opinion,
Blink
is appropriate.
twice.
And would have perhaps been not
I
appropriate
find this
had
guy
they been
particularly
frightened
interesting.
away from fear of
He's like, I just
prosecution
don't whatever,
and
man.
not done what the federal law had stated. And parenthetically,
He
this,
can
Pearson is about to
stop
get
him,
out.
but
And
I mean, he can stop him and say, hey, you know, dude, this is criminal court. And he's already tried twice to tell him, like, hey, let's stay focused. And he's saying, well, you know, and another thing and another thing and another thing. So like he's performing a filibuster. Exactly. He's got to, oh my gosh. Yeah. Hopefully we'll move on to the next one soon.
As it relates to the supremacy clause issues. The final slide is simply making
She's doing
the point that I
neck
made
yoga.
before, which is critical. As of December the 14th, 2020,
It's defense counsel's arguing.
because no conclusive result under Section 5
Yeah,
has been reached
didn't
by
have
the
to
Georgia
read all of this.
the Republican and Democratic presidential electors, they were all contingent.
Oh, it's the final slide?
Presidential electors. They acted appropriately, and
Okay.
that, Your Honor,
Contingent
I will
electors,
pass
not
the baton
fake
to
electors.
Ms. Pearson for her supremacy arguments.
Okay. Shoo! We made it out, everybody. We made it out alive. We made it out. All right. Let's see what we got. She's going to argue the supremacy clause under Article 6. See how this goes. Look at that microphone buzz. Stay hydrated, ma'am. Stay hydrated.
Good morning, Your Honor.
Good morning.
I'm Holly Pearson. I also represent Mr. Schaefer, and we also
Mr.
argue
Schaefer.
these issues for supremacy clause.
Okay.
And
This is Mr.
constitutional
Schaefer.
issues for all the other defendants who have adopted our arguments or who've also made their arguments that are here with the court today. I appreciate what you said, Your Honor. Obviously, we studied the earlier orders, the arguments, the briefing. And I think that the way I look at it is the court was only given about, 10 pieces of a 50-piece jigsaw puzzle to try to put it all together.
Oh my
And what I'd like
gosh,
to try to
a
do
jigsaw
is give the
puzzle.
court the full picture,
What?
put it in context to see how the Constitution instructs the court and the district attorney's office to act. I think there are sort of 4 areas where I think that there is going to be a lot of additional information and that is critical to why this is different and why the outcomes should be different. The first is the fact that presidential electors are created by the Constitution. And therefore there are the implications from that we'll talk about, those no traditional state powers or 10th Amendment reserved powers, and that's an important and very different situation. Number 2, the boundaries of the constitutionally granted appointment power. There hasn't really been any before now briefing or discussion about where are those boundaries and is the state inside of them and outside of them. And as we will see,
Yes, multiple
they're
lawyers
firmly
in RICO
outside of them,
cases.
and
Yeah.
therefore they cannot rely on the appointment power to authorize any action
So,
that they take.
again, and I'm just muting, I'm not going to pause, but so what happened here was Mr. Schaefer filed the motion for a demur, the motion to dismiss, and then the other defendants joined in on that. So multiple defendants joined, including Mr. Trump. So because his attorneys are the ones that first filed it, they are the ones that are arguing it. So we had the first set, which was an introduction piece with that attorney, and now she's going into the supremacy clause questions.
This turns this on its head from the traditional state powers that are presumed. Here, in the United States term limits case versus Thornton, the Supreme Court said that for entities like presidential electors or members of Congress that are created by the Constitution, the exclusive federal function that they form, the function they form is federal, and any power that any state has over them has to be delegated to it, and it's not reserved. So it has to be a specific delegation by the Constitution to the state to act.
Says one court
As the
once.
Supreme Court said, the states can exercise no powers whatsoever, which exclusively spring out of the existence of the national government, which the
You know,
Constitution...
it's hard to find a decent suit. I'm going to tell you that right now. It's hard to find a decent suit. If you don't get your suits tailored, it is hard. If you just go and buy suits, and the problem is, it's not that you can't afford to get a decent suit, it's just you don't have the time for it. I mean, I had a whole wardrobe full of suits. All of mine had to be tailored because of my size, because I'm so short. But if I hadn't had them tailored, I would just be swimming in a sack of potatoes. And I didn't have time to go, get everything tailored all the time. I had to really carve out my free time. So yeah, tailoring's really the key. And it's not that expensive. Again, it's just a matter of having the time to do it. Yeah, tailoring is the key. Absolutely.
Give the power... Did I skip one? There we go. Sorry. Technical difficulties.
To come to you.
What authority does the Constitution give? Well,
Yeah, my mother actually tailored my suits for me. So she's a seamstress, and I'm very thankful. And she tailored my wedding dress as well. So I'm very, very thankful. If you know a seamstress, you are just, that's living the good life right there.
has been, well, we have appointment power. That means we can do anything we want at any point and at any time with regard to...
Oh my gosh, Born to
presidential
Bark,
electors,
genius.
essentially unlimited.
Genius.
Well, that just isn't the case. The Supreme Court has made explicit that the appointment power stops at least before they ballot. And I think the construct of the Constitution makes clear that the appointment power of the
Ooh,
state, which
great
is
idea.
broad, when you're acting within it, they have broad authority to set the manner, means,
No, I
qualifications,
wouldn't say
procedures, etc.
again, I'm just muting here. I wouldn't say that the courts get on you if your suits aren't tailored properly, but there are some things where the judge will call you out. I've seen cases where judges have called out attorneys that weren't wearing ties. If they were, men, obviously, if they weren't wearing ties, they would get called out. I knew one person that got called out because his pinstripes were too thick, and that offended the judge. But that was in Texas, so things are a little different in Texas. Yeah, it goes for 6 hours, but we're not going to watch the full 6 hours. We're going to try to just get these first arguments out on the table and see what happens. Yeah, he said it just looked too gangster, so he sent that person home to change. So... Oh no, Quinn, I'm 5'2". I'm tiny. Oh my gosh. Yes, indeed. Yeah, exactly. My cousin Vinny, exactly.
The Supreme Court and the Constitution make clear that...
Oh my gosh, I love it, Annette.
...electors are meeting and balloting.
And how do you respond to the state's citation to In re Green and Chiafalo?
All of those, Your Honor, are grounded in the Supreme Court specifically grounds. It's sanction of the state's actions in the appointment power that is given to the state. So, for example, Chiafalo is a follow-up case to Ray v. Blair, which we'll talk about, which is cited here. Ray v. Blair was the first case the Supreme Court looked at about what's the limit on the appointment power of the state. And that case was not quite Chiafalo. It was, can we make presidential electors swear an oath of loyalty to the candidate? So in other words, faithless electors.
Extra ties. Oh yeah, absolutely.
Impose on an elector the duty to vote for the candidate of the party. And what the Ray case said was, yeah, they can can do that, but the only reason they can do it is because it is part of the
Every 30 minutes to shake himself
of the
awake.
electors
True story.
themselves, and therefore it grounds in the appointment. Giappolo is the next
Oh my
iteration that we
goodness.
talked about and that the state has relied on.
I've
Next
not seen a
iteration of
ruler
the
yet,
Reagan
Boxer
Blair
Mom.
case.
I've not seen a
And what it
ruling
said
yet.
is, okay, we said in Ray
That's so dumb.
that
How
you
is
make
this
the
supremacy
oath.
clause
In
relevant?
Giappolo, the question was,
Right.
they enforce it.
So,
And the Supreme Court specifically
you know, that's the question that they're arguing here. They're what she's trying to say based on a case that she's pulled, and of course the states argued back with other cases, but she's saying that the mechanism for who the electors vote for isn't specific enough. So getting fake electors was okay. There's nothing wrong with that. And because there was nothing wrong with it, that can't be charged as some kind of criminal wrongdoing, leaving out the fact that that's only a small piece of the RICO. That's only like 3 or 4 pieces of the RICO, and the RICO has 200 acts involved in it. So that's the first thing. But the second thing is she's saying, again, the federal constitution is the supreme law of the land, and because of that, it's more important than I mean, it will always win over a state issue. So what they're saying here is that, again, it wasn't clear who the electors are supposed to vote for. Oh my gosh, look at the judge. He's like, please, somebody. So that's what their big argument is here. Yeah, he's ready to be done. He's already like, put a fork in me, I'm done.
So ultimately, are you saying that anything an elector does,
We're doing great tonight.
because that is exclusively the purview of federal authority, the state has to stay outside of that?
well, anything they do as an elector. I mean, if they went out and committed a murder, I mean, the state would obviously be able to prosecute them for a murder. But here, in this case, they have been prosecuted for their actions as presidential electors. And it's not just me saying so. This is what the Supreme Court has said here. They've said that presidential electors exercise a federal function in balloting for president and vice president. They say that they exercise federal functions under and discharge duties in virtue of authority and conferred by the Constitution of the United States. So yes, once we're back in the federal realm and outside of the appointment power, the state has no authority. Remember, under the term limits case, it's the state's burden. Unlike the normal presumption where they have sort of plenary and common law and traditional police powers, that doesn't exist here. The term limits case makes clear they have to identify some specific authority that they have over these presidential electors. The only authority they have identified is the appointment power, and the appointment power plainly does not apply to the activities for which they have indicted the presidential electors, which are solely within the federal realm.
She's very well spoken. I mean, she's wrong, but she's very well spoken.
And that's really the point here, Your Honor. It's not whether the electors can do
No,
whatever
see,
they want. It's not which
Roberta,
someone
that's
gets-
that's this whole question is whether or not the fake electors were electors. And the problem is you have a certain specific process you go through in order to become electors. And that whole process was not accommodated. And then you have a specific certificate that you have to use. And they did not use the correct certificate, but they represented that they did. So that's why there's fraud involved. That's why it's such a mess, because they're trying to say it's fine for this extra slate of electors when instead it's impersonating a public official. It's impersonating someone who they had legally charted, legal electors that were doing their jobs. And then they had a batch coming up and saying, well, we're legally electors too. We're doing our job also, which is incorrect.
And that is what they're charged with here. There is no conduct in this indictment against my client or the other electors that has anything to do with the appointment power. It all has to do with the balloting, the meeting and the balloting, and that's exclusively federal. They have to show what authority they have, and they cannot.
And she's trying to say the state doesn't even have the authority to bring this
We also
case
have,
about the
preemption
electors.
issues. We have,
Yeah,
structural,
cosplaying,
constitutional
exactly.
preemption is what I call it. Then we have the more commonly known conflict in field.
So it is the equivalent of a public officer. So if they had dressed up in uniforms and gone to a law enforcement agency and said, hey, we decided we're going to be law enforcement, I mean, we have, it's different because electors don't necessarily have a particular way that they have to dress, but they do have certificates. They do have badges, and they recreated all of these things, recreated them without the expressed authority under the law so that they could come off as these alternate slates. Has there been times when there have been two sets of legal electors? So, Estelle, there was this whole idea of backup electors was really kind of hashed out with Nixon. And that was a big question in the Nixon 1960 election because there were some issues with Hawaii. So they weren't sure exactly what was going to happen. So they sent extras in, so to speak, or they had a group of people set up to go forward in case it was needed. Now, it was never needed, but it was never confirmed that this was even allowable. It was just something that they tried that nobody said anything about. And so with this Nixon idea, so we've got the Penguin Man involved, he decided to take it to another step, and they really just took it too far. So one time with Nixon, they've got this idea of what's going to happen if this gets screwed up because the state just joined the union 2 years ago. And then now they're saying, well, let's really give it a go. And they're finding out that it was actually illegal. Each state of alternate electors used the electoral certificate from Michigan. Mads, I think it was from Wisconsin. But you're right. Yeah, Wisconsin's. They used, and Wisconsin had some legitimate questions, but they sorted out those questions before those certificates, before all of that was done. Everything got sorted in time, but they went forward with it anyway. And they filed lawsuits for like a 24-hour period, just so that they could say there were lawsuits on file so that it was okay that they were alternates. So there was a lot of scheming involved. Yes, one of the states. Well, yeah, it's close. You're super close. You got it. But that is Wisconsin's form that they used.
He's not a presidential elector. He's not a congressman. He's just a guy who happened to have some evidence that Congress needed when it was acting in its judicial capacity, its quasi-judicial adjudicative capacity, to figure out which candidate from an election in Congress was going to sit in the congressional seat. So
yes, using the form over and over again, exactly.
Constitutionally entitled to do exclusively. And apparently, according to the Supreme Court, the local law enforcement didn't care for whatever testimony Mr. Loney gave because it apparently supported the candidate that they didn't like. And so Mr. Loney,
I'm not sure if Fox News has covered this or not.
Given the testimony through deposition, and because he was sworn by a state notary, the state charged him with perjury. And the Supreme Court ultimately said, no. This is a congressional dispute being disputed. He's giving evidence and testimony to Congress to help him in this adjudication. And therefore, this is too close to the functioning of the national government. This is too related to the federal system for us to allow the state to use its criminal laws to intrude here. And Your Honor, Loney and our case are virtually identical. In Loney, you have a federal election matter that's being resolved by Congress. There, it was a congressional contest. Here, it's a presidential contest. There, you have Congress acting in its adjudicated capacity, which it almost never does, right? It only has 2 instances that I'm aware of. These two, it gets...
The biggest issue with this case that she's using is she's saying this is just like this other case, but only the position of president and vice president include electors. So it is different. It is distinguishable from her fact pattern here. But that's what you do, everybody. You find cases close to your fact pattern that support your argument, and you try to make it so that that case can stand on its own. She's trying to, and she's actually doing a very good job with what she's got to work with. It's just not going to fly. I mean, and legally, it's just not... this would set a brand new precedent, and it would shift the power between the federal government and the state government if the judge here was to go forward and say, okay, yeah, you're right. So then now we have an issue of federalism. Now we have an issue of who has more authority, federal court or state court. And I don't think this judge in state court is going to do that. You think she knows it won't fly? I don't know. I think a lot of times we try things as attorneys to see what works and what doesn't. I think she's in the stage of, well, let's try it. Let's do our best. Let's give it our best argument. If it works, great. If it doesn't, it doesn't.
Gives you the right or ability to do something, and the state is interfering with your federal ability to do that. So the state cannot criminalize what federal law allows. And
Yeah, there's a
here,
lot of
they are
spaghetti.
criminalizing the submission of ballots that the ECA under
Yes,
section
Tina.
15
She's saying the state
plainly
does not have
allows.
jurisdiction to charge the fake
In
electors.
fact, it allows it 5 different times in one section of the statute, as you can see.
Yeah, I think
And to be clear,
she's
Your Honor, I think they covered this
she's
in
doing
the prior
good work.
district. It's been a while. So
I just don't think
reminder,
it's a good argument.
The ECA doesn't say you can just submit presidential
True
electoral
story,
ballots.
Lindsay.
It says certificates and papers purporting to be certificates. I mean, it's the,
I am too,
it's
Tom.
they bring me
Yikes.
your board, your certificates, your purported certificates, your, any vote or paper, any vote, any return. And so clearly the federal law authorizes
It's a little
it.
different than the Statue of Liberty, though. Where is it welcoming? I mean, where does it asking for this extra work?
Well, Your Honor, the
That was a
Supreme Court
awkward,
has said
nervous laugh.
Well, it's clearly the ECO was
This is
passed
Mr. Schaefer's
because
attorney.
the routine nature of giving these
Defense
multiple ballots.
attorney
I think
here.
that's covered in Mr. Cheely's documents pretty quickly. But
She's
whether they are asking
she's
for it
representing
or
one of the
not, they are
defendants
plainly
that Trump
saying it is
joined
authorized.
for the motion to
And they're
dismiss.
and it's part of their plenary authority.
That's
to
true,
be the
Peter.
adjudicator. And it makes sense if you put it in the context of
She's
what they're
trying
putting on. They're
to
acting in their adjudicative
change
capacity.
that. She's
And
trying
what they're
to
saying
go with a
is,
different
here's the kind of
perspective on
evidence
that.
we're gonna take, and some of it may be more persuasive than others. Certificates might be more persuasive than papers purporting to be certificates. Things with certificates of ascertainment from the governor might be more persuasive than, 16 buddies getting together and sending in something.
Schaefer was one of the
in
fake
But
electors.
we're gonna take it and we get to
He was one of the Republican Party leaders
here, and what the state is saying.
that was sworn in as the alternate or
We
fake.
get to tell Congress what evidence it's allowed.
Of your
to
play-by-play.
receive.
Oh, thanks.
Even though Congress has made plain that it will receive and adjudicate these types. And the president's
Right,
electors
Estelle.
here
Yep.
cannot
The legal certificates have bad
fill out
vibes.
ballots that Congress has said it will accept
funny.
and not be accused of crimes.
Oh my
That is
gosh.
straight up conflict preemption in its most classic sense. There is also a second type of conflict preemption.
Yeah, I agree,
Just for a
Mads.
second. And it's when the state obstructs Congress's purposes and objectives.
See, now that's how you drink some water, everybody. Good job. Very professional.
Because whether it welcomes them, hates them.
That's a great
or
question,
whatever,
Quinn. I'm not sure.
And by criminalizing the submission of them, they're obstructing Congress's.
I think it's just, she may have said, well, hey, this is an interesting argument, or for some reason, maybe she knows Mr. Schaefer. I don't know. I mean, it's a job. I don't think there's anything unethical with her making this argument. I don't think it's unethical. I think it's not a good argument. There's good ones and there's bad ones, and this isn't particularly good. But I don't think she's doing anything wrong here. I think she's just, trying to represent the best she can with what she's got to work with.
The congressional courthouse, so to speak, in this analogy, and telling them they can't submit their evidence.
Short
that
straw
Congress
could be.
somehow has the right to adjudicate it. They can't evaluate or adjudicate what they can't have. And they have said they will take it. They have said it's permissible.
Yeah, she
And the
knows.
state
She knows
has
it's
said
weak.
You can't send it in.
15 minutes, maybe. Probably a decent paycheck out of this one,
Also
too.
a sort of a usurpation or a
Yep, everyone gets a
rewriting of
defense.
the ECA, Your Honor. And Mr. Gillen touched on this a little bit, but here, what the ECA says, as Mr. Gillen made plain,
Why haven't...
here's what we're going to tell you, state. We've got all the power. Here's what we're going to.
All right, so why haven't they pled out yet? Again, a plea, great question. A plea, though, does involve saying you are guilty of something. So sometimes we're just not at a point where clients are ready to say, fine, I'm guilty of something. We're just not quite there yet. The closer we get to trial, the more you will see them start to say, like, whoa, we can't do this. So
The process is binding and decides who the lawful and only lawful electors of the state are. And therefore, we're going to stand.
yeah, I think she's getting
of anybody
paid.
through criminal, a threat of criminal prosecution or actual criminal prosecution. Inside the side, we decide didn't
Good
win,
question,
and
Jim.
keep
And
that
no,
person
not
in
really.
Congress. Well, that's not what the
We
ECA
have an
says.
hourly
As
rate
you
whether
pointed
we're
out,
in
Your
court or
Honor,
not
the
in
ECA
court.
says you default to the governor's certification at the very, very end of the process.
I'm not sure
No legal binding authority whatsoever on anyone
who's going to be taking a plea
until that
next.
time.
I
If they
would
don't meet
say
the safe
someone
harbor,
out of
Congress can
Georgia
decide
itself
to
should be
consider
taking a
whatever it
plea.
wants to decide.
None
It's
of the
not bound
native
by any
Georgians
governor's
have.
certification. It doesn't deem anybody to be the lawful. They're, as Mr. Gillen explained, they're all contingent electors. If they don't meet the safe harbor date, everybody's contingent until Congress tells us who isn't based on whatever they want to consider on January 6th.
That's not true, but it's an
And so
interesting
that
theory.
is clear obstruction of Congress's purposes because you're keeping them from getting evidence to which they are lawfully entitled and which they have said is permissible and available.
She probably has offered lots already.
Pervasive regulation. The Supreme Court in Bush v. Gore described ECA as so pervasive as to occupy the field. In fact, one justice even suggested it was so pervasive that maybe even courts could not come in and disrupt Congress's sole authority under the ECA. But it's particularly covering the field when
Practice, Tear Bear.
the state doesn't have
Lots of
any authority that they can point
practice.
to be playing on this field.
It is better to do it sooner rather than later, Jim.
And then this is related to what we talked about, Your Honor, but the dominant federal interest. We've talked about how power of Congress.
I'm not sure what he's doing over there. He's looking at that PowerPoint slide like it's going to save his life.
And the existence of this power is
That's the
absolutely
Electoral
necessary
College
to the
Act or
preservation
Electoral
of
Count
power. There
Act.
can be no doubt that of the primary federal interest, the dominant federal interest, candidly the only federal interest for the activities that we're
Yeah, the
talking
people.
about.
Yes, the prosecutors are here. They're going to come up next, Kristen. They're going to come up and have their responses to
And
their
so we would say
arguments.
The field is not only flooded and fully occupied
The
by
willpower.
Constitution and
True
ECA,
story.
but it's also got a do not enter sign for the state for the reasons we've discussed. And I think, Your Honor, in conclusion, I know we're always happy to see the conclusion sign. In conclusion, I just want to say, in the big picture, if we think about what we're talking about here, I think it makes intuitive sense.
GoPro.
If you look at what
That
the
would be
Constitution does and how it is
Oh,
structured.
that'd be funny.
I don't think it makes any intuitive sense that the framers intended for one state prosecutor in one state to take on a huge federal investigation.
I agree,
involving
Cecilia.
so many
I don't think it's
disruptive
gonna
forces
fly.
in the federal government and in the functioning of the national government. The Supreme Court and the Constitution, I believe, have tried to make clear that that is not within the
Reading the
boundaries of what the
business.
state prosecutors can do. It doesn't mean if there were crimes committed that those people walk or they go scot-free. What it means is which sovereign gets to be the enforcer. And here, it has to be.
Yeah, you have a
the
certain
federal
number of
government
times
because
you
the
can
state
appeal,
cannot ground
and then you're
its
done.
indictment. It has not grounded its indictment in any power given to it under the appointment clause or in anything else. That's the only thing else out there is the safe harbor. And there's
I
no
will
dispute
be
that wasn't done.
Jedi. Yeah, I will be
And I know in a
going
case
through
like
that
this,
as
we're
well.
pretty far down the road, and it's pretty difficult
Oh,
to say,
take
hey,
care,
well, wait a minute,
Deborah.
guess
Have a
what?
great
You don't
night.
have jurisdiction or authority to do this. But we're all, at the end of the day, bound by the rule of the law. And here we're talking about the supreme law of the land, what the Constitution tells us we have to do. And if we follow that rule of law here, Your Honor, this has to be dismissed.
Okay, get off the stage. Woo!
Thank you, Ms. Pearson.
All right, well done. Good job. Who's next? Crimes were committed, not war crimes. I think you're right.
Sorry, again?
You guys not popping out of screen sharing.
You're speaking tough language. I'll have to speak to Anthony.
Poker face. She's like a sleeping pill. True story. This guy's just been sitting there waiting for the end. They know they're on camera, but
Judge, I want to kind of start with the elephant in the room. A lot of the other side's argument is premised on this idea that their clients were presidential electors and that the state cannot regulate the conduct of presidential electors because of the Electoral Count Act. The elephant in the room is none of them were presidential electors. None of them are presidential electors. They've never been presidential electors as it relates to the 2020 election. And so those arguments do not apply as a threshold matter. Additionally, if their arguments even were to apply, it would require some type of evidence in the record that the court can make a finding about that would prove that they are electors or that they were electors. And so until that happens, first of all, the
It
argument's
was
premature.
easy.
That fact is, they were not electors, they are not electors, and so none of the analysis about preemption applies to them, does not apply to them.
You can
And
tell
so, of course,
he argues in court a
before we
lot.
started, or right as we started, your Honor's already rejected this argument. You've already found that there's nothing in the Electoral Count Act that either expressly or implicitly preempts state law. I'm not going to spend a lot of time on it, but I do want to kind of hit some of the arguments that the other side made just to preserve the
5
record.
years prison minimum for the RICO
Starting with
charge.
Express preemption, other side pointed to nothing. Conflict preemption, they say that number one, you can't comply with both Georgia criminal laws and the Electoral Count Act. That is not true.
You bet,
The
Jackie.
real 2020 electors did that. They complied with their responsibilities under the Electoral Count Act. Congress counted their votes, and they didn't commit any violations of the criminal code of Georgia. They also say that state law obstructs Congress's ability to count the votes. They say that this prosecution tells people that you
Right,
can't
mandatory
send in
minimum.
multiple votes to Congress. Well, that's not quite true. What this prosecution says, or what we've charged these defendants with doing, is sending in documents that say that they are the duly elected and qualified electors from the state of Georgia, which they were not. That's the operative language that is behind all of these charges. They are representing themselves as the actual electors, certified by the governor, duly elected and qualified, and they were never that. They were never that. If you want to send in a sticky note, a piece of paper, whatever it is that says, you know, I want to submit an electoral college vote for XYZ person, you can do that without getting prosecuted, as long as you are not purporting to be someone else or purporting to have authority that you don't have, claiming to be duly elected and qualified, and doing all of that with fraudulent intent. That's what they are charged with doing.
So the state's position would be if there had been a disclaimer at the bottom of the actual certificate submitted, otherwise the actions of meeting, convening, bringing in a court reporter, everything else, that was all authorized by the ECA?
I can't say that for certain, Judge, because it depends on a lot of other facts. It depends on a lot of other contexts. If that were the case, if there had been a disclaimer, that would have been taken into consideration, but that there wasn't a disclaimer. So I can't answer that with certainty, because that's just not what the facts are here. There wasn't a disclaimer. Again,
That kind of an argument,
field preemption, they say that the
I am going to pause it because I do want to hear more of what this attorney has to say. But that kind of argument shows you the difference between a trial attorney and an attorney that just argues appeals. So when the judge said, well, what about this? What about if they had put a disclaimer in the certificate that had said, you know, we're only here just if, you know, something happens to the original ones? Would that have made a difference? And he's saying, I don't know if it would have made a difference because those aren't the facts that I have. I'm working with the facts that I have. And that is showing how much of a trial attorney he is, where he's not walking into this hypothetical ground, which is what we do on appeals. That's what we spend our time with, is arguing back and forth with judges. Judges say, well, what about this? What about that? And then we have to argue those different roads. But he's saying, look, I'm just talking about the facts. Can they give lenience to Trump for the 5-year minimum? No, Cecilia, that's a mandatory 5-year minimum. Yeah, his answer was brilliant. I thought he's doing a really great job, but he's a straight shooter. It's clear that he argues in court a lot. He has a huge amount of experience. I think Judge McAfee had an excellent question. It's a valid question he's asking. He's like, well, what about a disclaimer? Let's see how far you are willing to go with your definition of what's an elector, what's not an elector. And this guy's like, I'm not going to play because that's not the facts here. So I think this attorney is doing an exceptional job of just keeping it straight, just a straight shooter. Meanwhile, Judge McAfee's kind of walking around trying to figure out all of these little ins and outs when it comes to appealable issues. So I think they're doing a good job. What's a disclaimer? So Judge McAfee was posing this hypothetical because this attorney is saying, hey, if you want to write down on a sticky note, all of the electors for for the state of Alaska go towards one person and for the vice president towards another person, that's fine. But he's saying all of these things that they did to put themselves out as actually true, valid, legal electors is what's gotten them into trouble. So that's what his argument is. So the judge was saying, well, what if they had written in their certificates, because they sent certificates to Congress and to the National Archives, and if they had put in those certificates, this is just backup, only if needed, would that have made a difference? So that's the disclaimer that he was bringing up. They did not include any of that language. One of the states, I believe it was Pennsylvania, wanted to include some of that kind of language. But in the end, and they may have, so Pennsylvania may not have charged anyone, but none of the other contested states did do that. Judge's expression, he didn't want that left out there in the gray area. Yeah, it would be nice. It would be nice to have had that answer. But I think he's doing a really good job of just kind of cutting straight to it. So
Field was occupied by the Electoral Count Act. It's not.
till they were caught. Exactly, JC.
Also in Defendant Shealy's brief, the idea that if Congress came back and decided to accept or certify a different slate, is the state then able to prosecute the slate that Congress ultimately accepts?
Again, Judge, that's not what the facts are here, so I can't answer that question. Because it depends on...
It plays in the preemption arguments, though, right?
Well, I can't quite answer that either, because there's first the question of, are we talking about complete preemption, or are we talking about as-applied preemption? And so I think it's very clear that there's no complete preemption here. There's no, absolute preemption. They didn't talk a whole lot about as-applied preemption. And that's a very fact-specific situation, and so different facts will lead to different outcomes. So I'm hesitant to wade into the waters of facts that just aren't present in this case.
Oh, there you go.
So again, turning to field preemption, just briefly to hit on this, they said that the Electoral Count Act occupies the field, that our criminal statutes are trying to regulate. Not true. The Electoral Count Act tells Congress how to count votes, what to do when you receive more than one vote.
Right. So preemption is this idea of which law is going to win. If there's a fight between a federal law, a federal administrative law versus a state criminal law, what's the order? What order are we in? So that's what they're arguing about here. So specifically, they're talking about the Electoral Count Act. So that's really what the argument is which one's more valuable, which one's more important. Because, too, federal law will always win over state law, but a federal administrative law, is that as important as a state criminal law? Or is it not? Is only a federal criminal law the same as a state criminal law? So those are the kinds of questions that they are going round and round about here.
It doesn't authorize people to send in whatever they want.
Oh, really?
The lawful votes.
All right, let me take a look.
It doesn't say, it's legal for you to do X, Y, Z. It doesn't say anything about what someone else is supposed to do. It says what Congress is supposed to do. And deciding what vote to count, that's not what the statutes in this indictment had anything to do with whatsoever. Then they also say that the federal interests are so dominant that the state can't regulate. Again, we mentioned this, I believe, in the prior argument on this issue, preserve it for the record, that our position is the interest is the same.
Wait, hold on. Okay, so I have an order as to Donald J. Trump denying defendants 74 motion to dismiss based on presidential immunity and denying defendants 113 motion to dismiss based off of constitutional grounds signed by Judge Chutkin. So she's denied both of his motions to dismiss. So, there you go. That did just come down. Thanks for telling me, VC. That is just a one-page order that she put out here, just saying, nope, she doesn't have any, and I don't see any analysis. I just see that she's like, nope, we're not doing that. So we're done. We're done with that. Oh my gosh, that's so funny. He's like, that's it. Nope, we're done.
Making sure the right vote is counted, that people don't hold themselves out to be a public officer that they are not. And so there's no conflict there whatsoever. And again, under the idea of field preemption, you have to look at what the statutes do. And there's no statute, no federal statute.
Okay, everybody. Oh no, I just saw the other order. It's 48 pages. Memorandum and opinion. So she did too. She did. I know. Oh no. So she just did one stating both of his motions to dismiss are out, but then she did go into a memorandum opinion on the immunity motion. So, oh my gosh, I'm taking a look at it here. 48 pages. Judge, what are you doing? You're killing me here. Oh my goodness. Oh my gosh. So this, I'm going to have to do this. I'm going to have to read this one out on a live, everybody, because this is pretty, wow, incredibly well written. So there's a legal standard that she set out. She's setting out that his presidential immunity is not absolute, and she's denying that motion to dismiss. So she does have, right, so she does have this opinion here. She's not tired quite yet. Oh my gosh. Oh, everybody. All right. So yeah, so she issued two orders. One saying, nope, we're not doing that. And then the other one's like, oh, and here's why. So love that. Got it printed right there. We'll print it. I might. We'll see if we've got some time. Oh my gosh.
People for pretending to be presidential election.
President of democracy. True story, Mads. Oh my gosh.
Federal government can prosecute people for the same acts, but we're not getting one set of laws that completely occupies a field.
I've thought about that.
are intruding upon. Just want to kind of preserve those issues for the record. And I'll move on now to some of the more substantive arguments. And I want to start with this because I think this is a very important concept. In the brief, they really hit on this idea that Georgia lacks delegated power to prosecute.
Oh, look, I found Mr. Schaefer.
To prosecute them under the
There he
United
is.
States Constitution.
Mr. Schaefer.
It's
his attorneys.
And I don't think that this is anything new to the court. The power is not delegated to the United States by the Constitution, nor prohibited to it by the states, are reserved to the states. The Constitution has to delegate specifically power to the federal government.
I'll have to figure it out. After all the arguments though that they've had, after so many motions they filed on constitutional questions and on this immunity issue, the fact that she was actually gone through and was this thorough, she's got something to say about it. So I'm for both. It's like she took both roads. She took the quick and easy route. Nope, you're done. And then she went through and said, paragraph by paragraph, she's going into each and every single piece. The indictment does not violate due process, she's writing. He had fair notice. There is no blanket immunity. Let's talk about due process. I mean, she's like written a bit of a novella here. She's novellaing.
Prior order is called the police power. We have the power to regulate fraud in our elections. Again, they attempted to turn the 10th Amendment on its head. And even if you take a step past that, the Constitution expressly assigns the states the power to regulate elections. We pointed this out in our briefs, but it starts with the Constitution, Article 2, Section 1. It expressly assigns to the states the power to appoint in such manner as the legislature thereof may direct a number of electors. That means that the states determine who their electors are.
You do, Sean. You still argue
The Electoral Count Act
if you
cannot
need
interfere
to.
with that.
If you've made the promise to argue, then you need to do the arguing.
We've made some cites to some of these other cases. In Ray Green, 134 U.S. 377 at 380, an 1890 case. Congress has never undertaken to interfere with the manner of appointing electors or to regulate the conduct of such
I agree,
election or
Roberta.
to punish
Yeah.
any fraud in voting for electors, but has left these matters to the control of the states. I don't know how much more explicit it can get. The Supreme Court recognized many, many years ago that the state has the power to punish fraud in federal elections. And this issue was kind of taken up again very recently in 2023 by the Supreme Court in Moore v. Harper, 143 Supreme Court 2065. State legislatures must provide a complete code, and this is dealing with the manner of holding elections clause in the part of the Constitution that grants the states the power to conduct federal congressional elections, but it uses the same language as it relates to presidential electors. So the state legislatures have to provide a code for congressional elections that includes regulations relating to notices, registration, supervision of voting, protection of voters, prevention of fraud and corrupt practices, etc. And we would submit to the court that analysis of the word manner as it relates to the congressional elections, the same word is used as it relates to presidential electors, and the same analysis applies. Manner means we have the power to prevent fraud and corrupt practices in our presidential elections. And as the court pointed out, the Supreme Court unanimously held and should follow that Article 2, Section 1 of the Constitution gives the states far-reaching authority over presidential electors absent some other constitutional constraint.
And that's the key with the
As the court
supremacy
also pointed
clause.
out, they said that the states have the power to penalize faithless electors. And this is talking about real electors, real actual presidential electors.
Absolutely,
If there's
reference
a power
materials.
to
Absolutely.
impose a penalty on the real electors.
I agree, Andy. I
How does it
agree.
make any logical sense that the state can't prosecute people who are not electors? I'm going to turn to the safe harbor argument. Defendants contend that if there's pending litigation upon the passing of the safe harbor deadline, then Congress decides who a state's electors are. That's absurd. That flies in the face of Article 2, Section 1. It just doesn't make any sense. Does not authorize, the Electoral Count Act does not authorize multiple slates of electors. It provides a procedure for how to determine which slate is the real slate under state law. And if you look at the Electoral Count Act of 1887, when those disputes arise, Congress has to look at state law and determine was state law followed. But we don't even get there. Because before you get to the issue of multiple slates having been received by the President of the Senate, there's this part of the Electoral Count Act that's being completely ignored. No electoral vote or votes from any state which shall have been regularly given by electors whose appointment has been lawfully certified according to Section 6 of this title, from which but one return has been received, shall be rejected. In 2020, one return was received from the state of Georgia. One return made it to the President of the Senate. And if there's any argument that depends on the fact that more than one return was made, it requires evidence, and there is no evidence in the record at this point. And so let's look at what 3 U.S.C.
They do have a timeline for how long they can go, but I don't know what it is.
After a presidential election, that the governor issues a certificate under the seal of the state, in this case under the seal of the state of Georgia. The governor transmits the certificate of ascertainment to Congress.
Yes, I'll upload this to my Tube of You.
Issued not one, but 2 certificates of ascertainment that said that these defendants were not the presidential electors for the state of Georgia. And so Congress received one return in 2020 from Georgia. It was certified pursuant to 3 U.S.C. Section 6, and that ends the analysis. All this other stuff about
Sure, absolutely.
multiple slates, that didn't happen. We don't get there. The defendants were never duly elected and qualified, ever. And that's the real problem. Again, there's one set of votes received by the President of the Senate. There's one set of electors certified by the governor as duly elected and qualified. The Electoral Count Act only contemplates that there could be multiple slates purporting to be legitimate. It does not authorize
Yes.
that. And I think I raised
Justice
the argument
O'Connor
in the
did
brief.
pass
I'll raise it
today.
again. For
Issues
example,
91.
Georgia's criminal code contemplates that people will commit crimes. And it provides instruction on what is to be done when they do commit crimes. Because there's some instruction on what you do when a situation happens, that doesn't mean that the law authorizes it. And again, conclusiveness
93,
under the safe
okay.
harbor provision does not mean that anyone can lawfully purport to be an elector, duly elected and qualified by the state of Georgia. Conclusiveness means that if certain requirements are met, it's conclusive that these are the votes. But it doesn't mean that if those requirements aren't
This is the
met, then they're not
prosecution
votes, and Congress
arguing.
decides who the real votes are. That's not what the safe harbor provision says. It's just not what it says.
It is,
Also,
Lindsay.
contingent electors
It is.
do not exist under federal law. And this was taken up in the federal court. I referenced it in our brief. I understand that it's persuasive authority here, but there's no reference to contingent electors.
Yeah, I agree, Navy. I think they did a good job at least trying to put something on.
Close to a contingent office
It's a good try, I thought, but
under OCGA 21-2503.
yeah,
What that
John, I think he
statute
did
says
nail
is
it.
that if an election is contested, then the presumptive winner takes the office on a contingent basis. And then if the election contest is resolved against that person, then the other person comes in and takes the office. It's not clear even that that applies to presidential electors in the first place. So this idea of contingent electors, number one, doesn't exist under federal law. Number two, to the extent that it might exist under state law, does not apply here. And also the defendant's safe harbor theory is incongruent with the Constitution. Again, Article 2, Section 1, each state shall appoint in such manner as the legislature thereof may direct a number of electors. This is granting the power to the states to decide who their electors are. And this is fundamental to the way that we elect presidents in this country. The states get to decide who their electors are.
Kelly.
They submit certification votes of those electors to Congress, and Congress counts them. Under the defendant's theory, their theory is that if an election contest lawsuit is filed in every state at 11:59 p.m. on the day safe harbor passes, Congress gets to choose who every state's electors are. Every state's divested of its constitutional authority to appoint its own electors, and the will of the voters is irrelevant. So if you file a lawsuit under their theory at 11:59 p.m., there's pending litigation, safe harbor evaporates, now Congress gets to decide who wins a presidential election. That makes no sense. Another example, let's say
They kind of did try to do that.
lawsuits are filed in Fulton County after an election. Does that mean that the Superior Court bench has to resolve all of those cases prior to safe harbor in order to preserve Georgia's constitutional authority to appoint its electors? It doesn't make sense. It doesn't make sense. I want to touch on Hawaii.
Oh, here's the Hawaii
We touched briefly
case.
on this, and the other side touched briefly on it, but we don't believe that Hawaii is relevant in any way. The facts and circumstances are completely different. Most significantly, in the 1960 Hawaii election, both of the certificates of vote ultimately had a certificate of ascertainment attached to them. That's not the case here. These defendants never had a certificate of ascertainment saying that they were the actual voter, or the actual presidential electors.
Oh.
And I'm not going to comment on whether it was lawful or not lawful, what those Democratic electors did in 1960 in Hawaii, but the other side's provided no authority that says what they did was lawful. They say
Yeah.
Hawaii precedent. Well, there is no precedent. There was a situation that happened in a trial.
Hello,
court,
Shadowhawk.
and we've had no appellate review of it. We don't know what happened there other than what happened in the trial court. There was a recount ongoing at the time. The facts are wildly different.
Yeah, they
The
are.
lieutenant governor of Hawaii at the time, who was acting as governor, knew that the Democratic electors were going to meet and submit.
It was
slate of
lawful in
votes,
1960.
and they essentially authorized them to do it.
Interesting.
Again, I'm getting into facts, and I'm trying to stay away from facts because it's not appropriate to get into facts in this type of motion. And again, it's legally and factually irrelevant that someone else wasn't prosecuted 63 years ago under different laws, different circumstances.
But on this point, just so I can set bearings, in your research of this, has an elector or someone purporting to be an elector ever been prosecuted before?
I don't know. Jim.
Oh, that's a
I
great
don't know the
question.
answer to that.
But you haven't found one?
I have not found one. I have not found one.
Interesting.
What I can say, if the court would like, that the archivist changed its procedures. The National Archives changed their procedures as it relates to receiving certificates of vote or things that purport to be certificates of vote after the 2020 election because of what happened. And now they've added an additional procedure to their kind of checklist of what we do when we receive these. And if it looks like something is fraudulent, they refer it out to their Inspector General's office to investigate. So just because it hasn't happened before, in our opinion, doesn't really have much effect on this case because we don't know those circumstances. Our position is that the motion should be denied for There's no provision of federal law that preempts Georgia from prosecuting election fraud. They pointed to nothing. The sets of law, the bodies of law, do not do the same thing. The general police power is reserved to the states, not the federal government. The Constitution expressly assigns power to regulate presidential elections to the states. And the Electoral Count Act does not in any way, while it may anticipate that multiple slates of votes might come in, it does not authorize them. They pointed to nothing in the Electoral
VC,
Count
go
Act
on
that
those
says,
trails.
you can do this. It doesn't exist. It's not there. And so with that, I'll take any questions that the court might have. And anything else, rely on the briefs.
All right, thank you, Mr. Wood.
Good, exactly, Georgie. It is a RICO.
All right, just only on this issue, was any party wanting to submit supplemental briefing?
Yeah, Your Honor, I would like to rebut, if I could, just a couple of points.
All right,
I promise I will be
let's
brief.
set a time limit.
Okay.
Why don't we just say about 10 minutes at the most?
I think that I can, although I am
Smart.
typically verbose, I think I can get that done, Your Honor.
That was smart to set that time limit.
There are two fundamental flaws that underpin virtually everything that Mr. Wilton just said. First of all, the state just made our point for us, Your Honor. They said they
What?
can decide who the real electors are, and because our folks weren't real electors, that all this consequence flows from that. That they don't get the protections of presidential electors. They don't get the federal protection. That is a fundamental misstatement of plain federal law.
That's not true.
Under the ECA, unless the state meets the safe harbor, which there's no dispute they did not do in this case, both sets of electors are contingent, and the governor's certification upon which the state is relying has absolutely no authority for them to rely on that, for them to
I agree,
decide
VC.
who the rightful electors are. That gets decided by Congress on January 6th, and not a moment before that when a state misses its state harbor. That is plainly the law under the ECA.
And so the two hypotheticals outlined by Mr. Wooten about 1159 and 10,000 cases, those are just unforeseen hypotheticals in the statute?
I think they are part of the reason the statute was recently changed, Your Honor, because I think there's been, if you look at the comment theory and the experts on the ECA, there's been a lot of consternation about the fact that you could file a lawsuit, but that is in Georgia's control. What the ECA says is, hey, if you, state, want to set up a process that allows you to get to a final decision by Safe Harbor Day, then we'll let you do that to be conclusive. Georgia can control that process. They set up a judicial process. If they wanted that done differently, Georgia could do that. They did not do that here, and so they have truncated.
All right, real quick, everybody. So the RICO, just to remind everybody, RICO means Racketeer Influenced and Corrupt Organization Act. So it means there's a common goal, criminal enterprise, and racketeering activities that have done overt acts, at least two or more, in order to complete that.
The ability of the state of Georgia to get the benefit of the safe harbor. But no, that doesn't change what the law says about what the authority is or is not here, or who the real electors are not. Their entire theory, their legal theories all flow from the fact that they believe they get to decide who the real electors are, when the Constitution is clear that only Congress gets to decide that. And when there's not a safe
95%
harbor
of lawyering
decision,
is
and there's a
confidence.
dispute, Congress decides on January 6th.
95%.
So comment about, oh, well, why is different? Because they both ultimately got certificates of ascertainment.
Good question, Tina. I'm not sure.
14th when they submitted their dual slates to Hawaii, so that can't possibly have any effect on the legal analysis here. The other critical flaw in the argument, Your Honor, is they fail to acknowledge what the Supreme Court has made very plain in United States term limits versus 40. And that is, they don't get the benefit of traditional or reserved powers. They don't get the benefit because presidential electors are created by the Constitution.
Oh my gosh, he tried to look at his watch, but he's not wearing one.
There is no traditional police power that applies to them. They must articulate a specific constitutional delegation that authorizes them to act with presidential electors. They have not, and they cannot. The law does not support their
You guys saw that, right?
of what the public power
You
is.
saw
We've gone through that. I'm not going to go through it again. We can certainly submit anything the court wants and our PowerPoint presentations. But that description of the appointment power as unbounded is entirely inconsistent with the law, with the Constitution, and with Supreme Court precedent.
And I didn't hear you address the In re Green case and the language that the state cited in that.
Yeah, I think we talked about that earlier, Your Honor. I believe the Green case is in the same bucket as the Chiapolo case, that it is grounded in the appointment power.
Oh my gosh, the
I have to
buckets,
confess,
not the
I've read a lot of cases,
buckets.
I could get some of them confused, but I'd be happy to submit something on that, Your Honor. But I believe Green, Chiapolo, Ray, and maybe even Burroughs all are grounded specifically in the appointment power.
He kind of does,
The
Suze.
idea that Congress would say, we don't permit anybody to send dual slates, but we're going to talk about how we're going to handle it 5 different times in one section defies any credibility. Their ability to count includes their ability to adjudicate, and they can't adjudicate what they can't.
She's had a couple of
They clearly
slips.
are permitting people to submit it, whether they're mandated to or not, have a duty to or not, they're allowing them to. ACA is plain that they're allowed to, and
This court reporter's
really
like,
can't be,
please. She's looking at her
disputed.
colleague like, let's go out together.
Also, the idea that the law doesn't talk about contingent electors, well, yeah, we've come up with that term, but it clearly does anticipate that there will be some electors that are certified, for example, by the governor, and some that might be
Maybe.
certified by the legislature. And here's how we're going to deal with that.
Maybe he
There might
ate
be
his watch.
ballots and papers purporting to be ballots. So whatever you want to call that, Congress might call it purported electors under the language they have used. It doesn't matter. It's plainly addressed and allowed under the ECA, and that is the point.
Is it the point? She is rambling.
The point we're making about In re Green and Chiapolo, Your Honor, the state cites Moore versus Harper.
He
I think
ate
there's
his
some kind of misunderstanding there. Nobody disputes
Oh my
that the
gosh.
state gets to act broadly in its appointment power. It's just that's not what it's done here. Same thing
It's
with
probably
Harper, they get to act broadly in
charging.
their control over
Yeah,
elections.
good point.
That is also specifically given to them under the Constitution. That has nothing to do with what the boundaries of those powers are and how far outside of them they are here. And I mean, I hear that, seen this in the other arguments, but it's very frustrating to have gone through at length multiple sites of precedent.
Lester,
multiple
we need a
sites of statute,
constitutional
multiple sites,
amendment.
all of that, and then have
That's
the
the only way
state
to do
say,
away with
"We
it.
cited no authority for this and no authority."
Gotta have an
By no
amendment.
authority, you mean the Constitution itself, Supreme Court precedent.
Yes,
and
it's all
federal statutory
recorded.
sections ad nauseum. Then yes, we've cited nothing. But if that is not what you
But
mean,
she's a
then we've
seasoned
cited all
professional,
kinds of
so
authority
she
that
knows
countermands the
what she
authority they
needs
have
to
cited,
do.
and they have not addressed the authority that we have cited. Let me check with my team just real quick and see if there's anything else we need to address.
Yeah, true story.
Okay.
Somebody keeps beeping. Okay, thank goodness. She's done.
There were a couple arguments that were raised in that PowerPoint that I don't know that they had put in the brief, so we would request maybe 10 days to provide me supplement to those arguments.
10 days?
All right, and any from the defense?
I
10
think if they
days.
submit something, Your Honor, we'd like the opportunity to respond if we think it's necessary, since it is our motion.
All right, so if the state, we could have that by COB on the 15th? Yes, Judge. And we can set a reply to the reply, or sort of rebuttal, I think at that point you're running into perhaps your break, but,
That's 2 weeks business days, so
we could say by the 2nd. All right. Okay.
the 2nd of January. Dang, everybody. What's happening?
Probably, hoping everyone packed a lunch. I think we probably need to take our a bit of a noon break here. I wondered if we could be back and begin the next argument before we're looping in, I presume by Zoom. I don't know if the other co-counsel are joining us in person or by Zoom for the what I was thinking would be some straightforward arguments on scheduling that they had raised, and then we can pause where we are and then resume. So my thought is come back at 12:45 and get started on the next argument. All right, let's do that then. We'll be in recess.
All right, everybody. We'll stop it there for tonight. I think that's plenty. Oh my goodness. Oh my goodness. That was a lot, everybody. It was a lot. I think this freeze frame sums it up perfectly. Perfect visual, everybody. Yeah, he's got a lot. He's got a lot of patience. So that was an hour and 31 minutes. And it's just the beginning. There's a total of 6 hours. Oh my gosh, it's a lot. It's a lot. So this judge I thought was pretty good. I think he seems to, when he makes a mistake, he seems to acknowledge it and correct it immediately. Like, I think he realized that he needed to set a time limit, and he set one. And if there were response briefs that they wanted to be done, again, it was like, let's set this up. Exactly. Yes, I know. I feel like I've lost something. I've gained something, but I've also lost something by watching this. So, oh my gosh. When they argue Trump can't go to trial until 2029. No, no, I don't want to watch that. No. Oh my goodness gracious. Yeah, 4.5 hours more. Oh my gosh. So, right. So, everybody, this was the motion for demur, motion to quash, also could be seen as a motion to dismiss. And this was the Atlanta case. If you're interested, this is the case number here, the Atlanta, Georgia case. And so they were arguing that the indictment should be tossed, that it's invalid. So that's is what they're arguing here. I think their arguments are fair enough to be made, but I'm not sure they will be successful. So, yeah, Josepha, so there were a couple of times where I noticed she had said the opposite of what she wanted to say. So rather than saying like, this is what Congress intended, she had swapped it and said, well, clearly this is what the states need to do. So it was a couple of moments like that is where I had seen her swap. And sometimes that happens where we actually say the other side's argument instead of our own side. That happens sometimes. So I noticed a couple of times. Oh my gosh. Yes, well, if you're compelled, Mary, you have to watch it then. No, it's fine. No, I think that's great. We all learn. We all learn. We're all learning. It's okay. That's the problems with story. Absolutely, John. Absolutely. It really is. That really is hard when you're trying to put it forth. Are they arguing that it's irrelevant that they tried to defraud the people? So, Adrian, the big argument is that they're saying okay, so Schaefer is the one that they're representing, these two particular attorneys. All right. And he's been charged with, false public figure and multiple pieces along with the RICO. So they're saying that those additional counts are invalid for him because of how the Electoral Count Act works and how the Constitution's written. So that's what they're saying. They're not even talking about fraud. They're saying the fraud doesn't exist, that this is just an alternate way of looking at who could be electors. And so that was their argument. Good night. Yes, good night, Jim. Thanks for stopping by. What was the final on this? Kristen, I don't know. I don't think we have a final yet. I don't think we have a final decision. Yikes. Can that be, everybody? Is that possible? Oh my gosh. Judge says no, they will flip. Yeah, I agree. I agree with that. They want all the evidence in the other case. Yes, I saw that as well. I have been looking through, Trump has filed 3 motions in DC, and I'll be honest, everybody, they're so lacking in factual basis. I'm really struggling. I had wanted to do some posts on his motions, or I had wanted to do a live on his motions, but the information is just bad information. So I can't even bring myself. And I thought, I can just redact the false information that his attorneys put in the legal filing. That's fine. I'll just redact it. But then there wouldn't have been anything left in the motion to read. So at this point, I'm really having to use my own discretion regarding Trump's motions because there's so much false information being filed in court. It's absolutely ludicrous. It is ludicrous. And when you start to doubt the honesty or an integrity of a legal document, that really calls into question a lot of different things. So I'm just now I need to be careful about which of Trump's motions I will be going through, only because they're just false. They're just factually false. So I've kind of had to take that kind of had to take that corner. Does this happen in other cases? No, Suze, I've never seen this happen before. I have never seen a case where attorneys repeatedly filed false information and did not get called out and sanctioned for bad faith actions. We would get sanctioned and we could lose our law licenses like within a week, basically, for doing some of this stuff. I've never seen this before. It's horrendous. They should be getting into trouble for it. They should be. Are they? I don't know, but they should be. Because you should not be able to just file false information in a legal document in a criminal case, in any case. And some of the information that again, it's just clearly false. It's like clearly saying the earth is flat. Like you can't put the earth is flat in a motion and file it in the court and, say that you have integrity as an attorney. You cannot do that. And that's what's happening here. So I'm not sure why. I'm not sure why it's not happening. I'm not sure at this point. But it's hard to watch. It's hard to watch because I want to be able to get that information out to everybody, but because it's so false, I just don't want to be part of the perpetuation of that false narrative. Yeah, there's proper procedures. Exactly. Well, yeah, if the sky was actually falling, sure, but it's not. Who's responsible for going after these attorneys? Well, you have to have people file bar complaints against them in whatever jurisdiction they're licensed in. So you would just talk with and file complaints with their bars. So anybody can do that. Anybody can file that, but it's frustrating. I would really, I find it very helpful to be able to go through documents and point out the mistakes and have people ask questions. I think that that's very helpful. But on the other hand, I think there's so much, I would say about 85% of his last 3 motions in DC are just not true. They're just not factual. So that to me is just not worth it to get in there for that 15% of the arguments that he has. So it's a little frustrating, but we'll figure out a way through it. But so just to kind of give everybody a heads up. So if you're waiting on any of his motions out of DC, I just cannot bring myself. I've tried, I've redacted, I've reprinted, I've tried, but I can't get around the fact that they're just putting completely incorrect information in these motions. You seen any other attorneys reference dissenting opinions? Not to this degree, Jim. We can use dissenting opinions if we feel like, just because it's the dissent, we feel like it's a really good argument and they should rely on that. But that's like your Hail Mary to use a dissent. That shouldn't be your primary focus. Your primary argument should not be a dissenting opinion. That's not what it should be. It should be like, this is all I got. This is the last thing I'm going to throw at you is this dissent. So for delay purposes, true. But I think also just because, honestly, I think they want some of this information to get out to the public. And I think it's so frustrating because if you came across this court document and you didn't realize that this is bad information put in a legal document, you might say, well, it must be true then. It's filed in a legal document. And that's, to me, is what's so frustrating, because if people don't understand that this is not true information and still is filed legally, they're going to start assuming it's true. So it perpetuates this lie, this bad information. And that's a shame. And I think that's bad faith on the part of the attorneys. They should not be filing that. So it's very frustrating. It is, Mads. It is. And I don't know what to do about it. I don't know. I'm sure tons of other attorneys have posted about it or have made their thoughts known about these frivolous, but they're not even frivolous. They're just factually incorrect filings. And many of his attorneys have been sanctioned. So I'm sure lots have spoken about it, but it wasn't really until this last couple batches of motions where I saw it's just too much. It's just too much bad information. Why aren't the judges doing anything? Lisa, I don't know. I don't know. I know the judges are walking on tiptoes. They're trying to be careful. They're coddling, they're kid gloving. But this blatant, the only judge I've seen trying to do anything is Judge Ingeron, and we've all seen what's been happening to him. So it's just really frustrating. It's hard to watch. I think they will come back and get things sorted out soon, but in the interim, it's a mess. It is. Yeah, it's a lie, Denise. It's false information. I don't like the word lie because I think lie can be interpreted a lot of different ways, but if it's not factual. So, can you report them the way? Yeah, absolutely. Absolutely. And we do. And we do report them. And I'm sure they do have reports, but it's just really, it's conduct unbecoming an attorney, and it looks terrible for our field. And I wish, my thought has always been we win, we lose, but no matter what, we play fair. And they're not here. And it's just very frustrating. I think they will face the music after the trial. I think so too, Adrian. I think so too. I think a lot is going to happen later. I think because it's going to take time. And we're still just we're doing triage right now with all of these cases. We're trying to stop the bleeding, so to speak, in these cases and get everything filed in time and get everything put on the calendar in time. So it's rush, rush, rush. But once the bleeding has stopped and triage is over, there's going to be some pretty high prices to pay. Trying to appear neutral, yes, absolutely, but yet still uphold the law and decorum. And it's difficult, very difficult. We never had to deal with people like this. Exactly. Everybody, and we knew that there were some basic tenets of being an attorney, and, filing intentional false information in motions. That's a huge no-no, and you're not supposed to do that. And the fact that they are doing that and getting away with it regularly it's very difficult. So, but hey, I'm glad it's not me. They're going to have to sort that out with themselves and get that sorted. Any weekend plans? So, great question. Great question, everybody. What do I have? I'm not sure. I've got this really big order that just came out of DC regarding presidential immunity. So I'll do that. But primarily right now, we are getting things ready for my husband is a teacher, and so his semester's about to end. They're about to go into finals, so we're getting things ready for that period of time. So it's very exciting. It's a very exciting, fun time. Can you cover the law that protects the woman in Ohio charged? Oh, Cecilia, that's a really tough situation. That's a tough case. I've got it on my list. I'm taking a look at it. But I'm not really sure. So will you do DC? I'm not exactly sure when I would like to do DC as soon as possible, but I'm not exactly sure when I will do it. I do have my sub chat only on Sundays, so I'm wondering if it might be best to just wait and do it on Sunday with the sub chat going. So yeah, Kristen, exactly. We've got the sub chat Sunday, so I'm not sure. And then I do have some things I want to get ready to set out for the lives for this week too. So yeah, I know, Mads, exactly. Yeah, that one was pretty heavy. So I tell you what, I will put up I'll post a story letting you know when I will do the DC case. So just keep an eye on my stories, and I'll keep you up to date that way to kind of distinguish it. I won't make a whole video and put it in with all my other posts. I'll just add it to my stories. I want to look through it. I haven't read through it yet, but I'll look through it, and that'll give me a better idea of when I will be able to go through that order. So I will do that for sure. Any of these going to be televised? Any of the cases? Well, we've got Fulton will definitely be televised. I'm not sure about the situation in New York, if that will be, probably not, but oh yes, I will definitely be there. I'll be there for sure. Have you looked at the new Oregon? No, I haven't, Thomas. Really? Let me write it down. Let me write that down. We putting it on the list, Thomas. It's going on the list. Okay. All right. So let me add that on. On the list, and then Ohio is still on the list. It might be a while before I get to that, though. Thank you for your time. Oh, my pleasure. I'm so glad you could come by and hang out with us, Navy Vet. It's always great to see you. Q&A sub chat day, not to interrupt normal broadcasting. Yeah, we could do that, Kristen. That might be really fun. Annette, thank you. Oh, absolutely, absolutely. Yeah, we might be able to do that. Let me write that down. Write it down. We'll see. I've got a little pondering to do about what the next batch of topics will be and what we'll do. But I will make sure to post on my stories when I do the DC order, and it'll be sooner rather than later, so we can get that up and going. So always refreshing. Oh my gosh, I do try. I do try. We kind of keep this a safe space over here, don't we? We do our best, as best as we can, for sure. But on that note, everybody, I'll go ahead and sign off. It's been great to see you all. Thanks for hanging out with me on this Friday evening. It was something else. But have a great night, everyone. I will be posting real soon and letting you know what the schedule will be. So have a great night, and thanks again for coming, everybody. And I will see you very, very soon. Kristen, I'm glad you're not so bummed. I missed you. Happy to come back on and hang out for a while. So good night, everybody. Take care.